Right, let's start. So first of all, hello and welcome to Mayor Brown's 2022 Banking and Financial Services Litigation webinar on rising ESG-related litigation risks for financial services institutions. My name's Ian MacDonald. I'm co-leader of Mayor Brown's Global Litigation and Dispute Resolution practice, where I act for banks and funds. Your presenters today are Mark Hanshay, who's a partner in Mayor Brown's New York office and co-chair of Mayor Brown's Global Banking and Financial Litigation Action Group, Paul Forrester, a partner in corporate finance and securities in our Chicago office, and James Whitaker, a partner in the litigation and dispute resolution practice here in London, where he acts on complex commercial disputes. Before we begin, we'd like to mention a few housekeeping announcements. Please note when accessing Mayor Brown's webinars via our WebEx platform that we suggest avoiding software such as Citrix to decrease disruption or quality loss. Secondly, today's program is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presentation. If you have any questions that are unanswered during the presentation, we invite you to submit questions using the Q&A feature on the right side of your screen. If there are any unanswered questions during the presentation, we will do our best to follow up with you directly after the webinar has ended. For those in the US regarding CLE credit, we'll provide an alphanumeric code during the presentation. In order to receive CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. Please return this form within 10 days of the event by either scanning or taking photos of the form and emailing copies to cle-events@mayorbrown.com. And for those in the UK for CPD, please send an email requesting a CPD certificate to our Learning and Development Department at ld@mayorbrown.com. So with that out of the way, it's time to get started, and I'm delighted to hand over to Paul.
Ian, thank you very much. Well, welcome everybody. Some of you may remember that we did a version of this same presentation last year. I think it would be fair to say as we prepared for this, all of us have been struck by just how much has gone on in that year. Next slide, please, James. Well, many of you are well aware of ESG and digging in deeply into the issues that it raises. This slide I include because it's always a useful reminder, I find, to just make the point that this is a very broad topic and includes a lot of things that previously would have not been given the same attention that they're now getting as a result of the focus on ESG. You'll hear that spoken to a couple of times in our presentation today, but employee relationships, gender diversity, what ESG has effectively done is really given a megaphone to complainants about those matters, and they have obviously a much heightened risk profile as a result. Next slide, please. Why do we talk about ESG? Again, this is mostly self-evident. Obviously, IPCC continues to produce alarming reports of the risks posed by climate change. We had a seminal Conference of the Parties 26 in Glasgow last year, at which we saw a number of very significant industry and trade groupings. Some of them are listed here. We've been fighting COVID-19 for several years, which has stressed everybody. And all of this is in the context of a high level of general societal angst reflected in Me Too, Black Lives Matter, Yellow Vest, and other movements that are assuming a significant amount of political importance and are becoming more influential. Next slide, please. Economically, the impetus is people like BlackRock and Larry Fink sending annual letters to shareholders and significantly ratcheting up pressure on boards of directors and others. You have underlying that a significant rise in shareholder activism. I'll be talking about that a little later, but it's quite clear to us at least that climate proposals and others falling under the rubric of ESG are rising. Last year marked the first time that there was 50% approval for climate-related shareholder action. We saw a minority shareholder take over significant board representation at ExxonMobil. So there's a significant amount of shareholder events that are going on related to ESG. Again, just a striking amount of money is now currently being managed to ESG-linked investment plans and schemes, and it's growing at an accelerating rate. That number is Bloomberg's, that will hit 50 trillion by 2025, and that was made middle of last year. Officially, we see significant numbers both in Europe and in the United States being managed to, again, ESG mandates. And a wild card is, only because we don't know when it will actually occur, but the estimated $30 to $70 trillion of wealth transfer from baby boomers to millennials, all of whom, when surveyed, seem to be much more militant and view as much more important ESG. And obviously, that will occur in all likelihood by 2050. Next slide, please. The challenges for ESG are also well known. Definitions, data quality, especially scope 3 emissions, and I'll be talking about that a little later. And obviously, the difficulty of making it comparable continues to challenge us, and there's no single or no even harmonized reporting frameworks. Although TCFD, which we'll talk about, is clearly becoming the leader and becoming a common first choice. And the other significant challenge is just the lack of internal board management ESG experience, and obviously the need to engage third parties and experts to assist companies. And they continue to be in high demand. Next slide, please. The definitional challenges are we don't necessarily agree on all the core elements. We may or may not be including biodiversity when we talk about ESG, and obviously there are embedded in ESG climate in particular, significant controversies about the role of nuclear, the role of natural gas as a bridge fuel, and things like biofuels, which we're trying to expand, have significant land use change effects. And so that controversy will not go away. Unfortunately, it's even less clear where we are on social and governance. But notwithstanding that, there is overwhelming pressure and a growing interest in making us tell a better ESG story. Next slide, please. We talked last year about the momentum for mandatory ESG reporting. It's ratcheted up significantly. In the United States, where I am, the Biden administration obviously had a very early executive order thrusting all of government at climate-related risk, which the president had described as existential. The FSOC produced a climate risk report. The BIS is consulting on climate risk management by banks. In the United States, again, the OCC and FDIC have both issued climate risk management expectations. More recently, the SEC has issued a sweeping and profound climate disclosure proposal. And the Division of Enforcement at the SEC has again announced that 2022 will be ESG will be an examination priority. And for the first time ever noted that greenwashing is something they're going to be examining. You'll hear a lot about greenwashing during the course of today's presentation. The SEC proposal obviously is still expected to be adopted in something like the proposed form by year end, although legal challenges are certainly expected and likely in our view. Next slide, please. Switching to outside the US, the EU taxonomy continues to be expanded and implemented. Canada is now requiring mandatory climate reporting on banks and insurers. The NAIC, obviously for insurers, has established a couple of years ago a climate and resiliency task force, and again has as its focus for 22, as it did in 2021, climate risk. The Federal Insurance Office has issued an RFI about climate. The New York Department of Financial Services has spoken now several times about its expectations for climate risk management by the institutions that it regulates. And then FHFA has now included climate change in its strategic plan. Again, it's almost becoming a daily event. Next slide, please. Last year, we posed these questions. Clearly, we had expected that there would be a principles-based proposal from the SEC. It turned out that we were wrong on that regard. The SEC proposal, as many of you are well aware, is profoundly prescriptive and requires very specific and very granular information. Assuming that it's adopted as proposed, as is apparently likely, we won't be talking about materiality much, but assuming we are talking about materiality, there really are some difficult questions that ESG raises. Is it in fact material to reasonable investors, or is it, as some suggest, only areas of concern and interest of a few very large institutional investors? How do we deal with the 10, 30, as long as 50-year climate scenarios that actually implementing TCFD and other reporting requirements? And obviously that will raise questions about the various net zero pathways. And all of that has to be judged, again, to be material, notwithstanding that significant uncertainty. Of course, you have to take all the climate data and translate it into financial consequence. And obviously that will involve its own set of projections and assumptions. And all of this, of course, is brought home when you have to think about the availability of existing safe harbors for the disclosure of forward-looking statements like the ones which are going to be required, it appears. Next slide, please. As both James and Mark will note probably, there are significant uncertainties about the effect of ESG statements. I think it would be fair to say many are, in fact, just aspirational. They're not actual, factual statements. And again, there's important questions about, can investors justifiably rely on merely aspirational statements? And do they have a remedy if, in fact, losses can be causally related? I think we would draw the experience that many financial institutions have with the equator principles, which govern the international project finance, as a guideline for the sorts of claims that arise and how they're presented and who presents them in this regard. But again, this is a brave new world. And certainly, as again, both James and Mark will speak to, we've got new types of plaintiffs showing up. And candidly, they seem to have different interests as to desired outcome. So there's a lot to work through here. Next slide, please. As I noted at the outset, one telling feature of all of this is ESG-related shareholder activism is rising and rising rapidly. You could certainly see from these slides just the dramatic increase in shareholder resolutions relating to environmental issues in particular. And certainly the number of them, as I mentioned, is almost a daily event. Financial institutions were noted this year to be the target. Large banks in particular were targeted by several institutional investors for climate-related proposals. They were defeated, but there's still substantial support from shareholders for the proposals that were being made. So that is increased year over year. It's likely to increase next year. And so all financial institutions and others who see those proposals are going to see increased pressure to act. And I would note utility companies, which obviously have been affected by this, are now starting to voluntarily agree and settle out those proxy claims with the claimants, and they are agreeing voluntarily to increase reporting, to an expansion of their net zero commitments and the like to respond to them. Next slide, please. And obviously all of us read the papers, and the reputational risk is quite real and is rising rapidly. These are just two examples that I pulled. I could have pulled hundreds, I suspect, had I put my mind to it. But as again, James and Mark will speak to, this is a very real aspect to ESG. And unfortunately, ESG has given a significant voice and a louder voice, perhaps, to a lot of things that would not have received the attention they're going to now. Next slide, please. And before closing and turning over to James, I just note it's not just climate. This slide is a little colorful and hard to read, but what it shows is that there are, in fact, quite significant shareholder proposals being made for health, for racial disparity. Racial audits are becoming a fairly frequent event and common at many large companies, and they're rising over time, as you can see from the chart here. And as the right side of the slide notes, Apple actually was stuck with a shareholder's proposal to do a civil rights audit. Amazon, I believe, was subject to the same and has just agreed to do the same. So they're coming, and they're coming fast. I would note, in closing again, before turning over to James, there's a maturation as well that's evident in the shareholder activism. It's now not just going in for, I want better greenhouse gas emission reporting. I want you to do scope 3. And if you haven't done scope 3, I want you to do scope 3 on a certain timeline. And the pressure is going to be a little more surgical. That might have been the case a couple of years ago. So with that very general overview, I'm delighted now to introduce and to turn the call over to James. We'll talk about EU matters.
Thanks very much, Paul. Good morning and good afternoon, everyone. It's a real pleasure to be speaking with you today. What we want to do now is talk a bit about how the rapid development and evolution of ESG, which Paul has outlined, and some of the themes that he's touched on, are increasingly giving rise to specific related regulatory and litigation exposures. And of course, the latter often follows the former. As a broad proposition, and there are exceptions to this, but it remains the case that banks and financial institutions are not being specifically targeted in litigation in the same way or to the same extent that participants in other industry sectors are and have been for some time. That said, financial services activities are undoubtedly now under more regulatory and general scrutiny through the ESG lens than was the case historically, even a year ago when we delivered a similar session. So the underlying theme here is the extensive regulatory activity and interest that is really driving the ESG agenda. And that is at least as much the case, probably more so in the European and UK context as in the US context. And of course, history shows us that tighter regulatory regimes generally eventually lead to more litigation exposures. So what does that regulatory activity look like? Well, in Europe in particular, the main point is that the multiple and varied voluntary disclosure frameworks that are in play are increasingly being replaced by mandatory requirements. And this firming up is a trend that will only increase. I'll mention just a few of the probably most consequential developments that may lead to liability exposures from a handful that are listed on the slide, and there are more, of course. But very briefly, we have the EU taxonomy and the Sustainable Finance Disclosure Regulation, which has been enforced now for a little over a year. The SFDR, of course, imposed mandatory ESG disclosure obligations for asset managers and other financial market participants, requiring asset managers to provide standardized disclosures at both entity and product level. The MiFID II directive, which governs markets and financial instruments, will impose from November of this year, November 22, certain changes to product governance obligations, including to incorporate an analysis of sustainability risks. Similarly, the CSRD, the Corporate Sustainability Reporting Directive, will amend the existing reporting requirements to include a requirement to report according to mandatory EU sustainability reporting standards, amongst other things. In the UK, banks and insurance companies are already required to produce annual statements addressing policies and due diligence processes in relation to their environmental impact. And the financial services regulators over here, the Financial Conduct Authority and the Prudential Regulation Authority, continue to focus on obligations in this context. And just last week, this isn't on the slide, but just last week, the UK Treasury Department launched its Transition Plan Task Force, which will focus on developing a standard for disclosures of climate transition plans. So the scope of reporting requirements around not only performance, but also transition planning is broadening. And very briefly, in the social context, we have the UK Modern Slavery Act's requirement for mandatory annual modern slavery statements. This is also reflective of the trend towards mandatory reporting, and the CSRD in the EU context will impose a due diligence duty on in-scope companies to identify and remedy actual or potential adverse impacts on human rights and the environment. So there is very evident growth of regulatory and legislative pressure on all organisations to focus very closely on ESG performance and disclosures in particular, and this will continue to define the regulatory landscape. But a dual emerging theme, which to some extent underlies this developing framework, which I'll come back to, is the regulators' increasing focus on the phenomenon of greenwashing. Paul's alluded to this already. Whereby organisations misrepresent, whether in an advertising context or otherwise, their green credentials. Indeed, the EU and the UK financial markets regulators, so ESMA and the FCA respectively, in addition to the SEC, have both explicitly made addressing greenwashing strategic priorities. Now, this is a particularly tricky area for any company and or FI, not least because it remains the case that there is no absolute universally agreed metric or taxonomy for assessing how labels relating to green or sustainability or other ESG principles should be applied to particular or specific products. Nonetheless, the mislabeling or misdescribing of particular funds or strategies or assets is emerging as a real key area of regulatory focus and indeed of liability exposures. So that is a snapshot of the developing framework in the UK and Europe. What about actual litigation? Well, first, let me define briefly what we mean when we talk about ESG litigation. Essentially, on the one hand, we're talking about specific actions targeting governments, companies, and financial institutions that fall within one of the three constituent elements of ESG. And on the other hand, we're talking about the overarching or perhaps underlying risk that really straddles all three of these elements of ESG, and that relates to disclosure-based claims. And this is really where the ESG liability exposures are emerging. So going back briefly to claims relating to the specific elements of ESG, in the environment context, the climate litigation cases have been a feature of the landscape for some time, and this continues to emerge. And we'll talk a bit more in a moment about how these cases are pivoting to target private companies. In the social context, we've seen the rapid rise of societal issues that Paul touched on over the past really few years, and the prevalence of these issues in the public conscience starting to play out in litigation. This has been most notable, for example, obviously in Me Too related claims, in the diversity and inclusion disputes that have arisen, and the emerging business and human rights litigation that we're seeing, as well as more recently privacy and data security litigation, which continues to develop rapidly. And finally, in the governance context, the focus on individual accountability and responsibility for corporate performance continues to grow. And we touched on this a year ago, but this is really an area of significant activity. One example of this is a very recent development here in the UK, which is, I would suggest, highly significant in this context, not least because it may provide a framework for future similar actions. And that is the recent targeting of the board of directors of Shell by the very well organised, very well funded climate group called Client Earth. Now, Client Earth are pursuing the directors in the English jurisdiction on the basis of alleged breaches of the directors' statutory duties under the English Companies Act. So this really reflects a point I'll come back to in a moment, which is the developing range of case theories. But we have specific liability exposures in relation to each of those three categories. There is, however, this overarching risk which directly arises from the developing regulatory frameworks that we've touched on, and that relates broadly to disclosures. And particularly as disclosures increase and the level of information in the public domain grows commensurately, failure to meet targets or to live up to aspirations may become, and in some cases is becoming, actionable. And this is really where you see the exposures from each of those three individual strands of ESG coming together as a distinct litigation risk, namely what is being disclosed, what is not being disclosed, and what do those reveal about performance. So ESG litigation has a number of distinguishing characteristics when compared with what might be described as more conventional litigation. The very nature of much of the emerging liability risk reflects the interrelationship and overlap between the three strands that I mentioned earlier. Now, one of the defining characteristics is where these claims come from, so who the plaintiffs or the claimants are. And the starting point is that the pool of potential claimants is really significantly broader, which in part reflects the fact that ESG issues impact simply far wider groups of individuals or populations. But also in terms of who is pursuing claims, this is really not limited to what one might describe as conventional litigants. What I mean by that is that multiple stakeholders are increasingly engaged in what is happening in the ESG space and are moving into position, whether they be private claimants or NGOs or pressure groups and other stakeholders besides, who would not historically be considered to have standing, so would probably not be able to pursue a claim, and even if they had standing, would have encountered insurmountable causation difficulties, for example. those are increasingly capable, those issues, those difficulties are increasingly capable of being overcome, whether by way in the causation context and in the environmental litigation context, by virtue of climate change attribution technologies and the like. But relatedly, traditional concepts of where duties lie and how they arise are being revisited. And the Shell directors case I mentioned is a good example of that dynamic. And that is closely related to the second point, which is that the ultimate aim of this type of litigation and the motivations for bringing these cases can be different from the conventional recovery of monetary damages. Is commonly focused more on affecting behavioural change of the target organisation. Most evidently, we've seen this in the context of damaging environmental practices, but it is starting to manifest in the context of social justice and governance issues also. We talked about some of these themes a year ago, but this is now starting to emerge in very concrete ways. Taking these factors together, the key point really here is that organisations, whether they be corporates or financial institutions, whether in the context of raising capital, of investing, of selling products, or simply of conducting business, they really need to have regard to a far broader range of stakeholders than just shareholders and investors. So we're seeing new or different categories of plaintiffs or claimants emerge with different motivations. There is then this new type of exposure emerging, but a key question is who this litigation is actually targeting, because that too differentiates this somewhat from more conventional litigation. Much of the early stage ESG litigation, which broadly was environmental climate litigation, and that continues to represent the majority of the litigation in this area. The majority of it targeted principally national governments and governmental institutions. And you see on the slide just a small number of relatively recent cases targeting specifically the UK government and the Belgian National Bank. There are many others, and these build on multiple previous cases, particularly in jurisdictions such as the Netherlands and Germany. And they really clearly demonstrate that the fact that these cases continue to be filed and pursued demonstrate that governments, both regional and national, remain very much in the crosshairs. But the scope is clearly widening beyond just governments, and private companies are increasingly being targeted by claimant or plaintiff groups, often on similar case theories to those on which governments have previously been targeted. The most notable example of this is the increasing reliance on human rights-based theories. And the Shell decision in the Dutch courts last year, which is the case you see referenced on the slide there, this really represented a sea change moment in terms of the development of the law in this area. This was the first time a national court, and this was the Dutch Federal Court, first time a national court imposed a legal obligation on a private enterprise to reduce its CO2 emissions in line with the Paris Accord, the Paris Climate Agreement. Now, the case theory in that litigation was based principally on elements of the Dutch Civil Code, but human rights arguments were also deployed. And it's likely that this will have wider ramifications beyond just the Dutch jurisdiction, and in all likelihood will set the scene for much future climate litigation. So it's a highly significant case for many reasons, but not least because of its impact on the ability of litigants to target private enterprises. I should add here that Shell is appealing the judgment. That appeal was just filed last month, or in March, just earlier this year. So that is definitely one to watch. But this has started to play out in a number of cases, some of which might be described as copycat cases in the sense that they are premised on similar theories. And this is particularly evident in, for example, France, where the courts are considering a growing number of lawsuits based on alleged non-compliance of target companies, of defendant companies, with a provision of French law that dates back to 2017, known as the duty of vigilance. This requires in-scope companies to publish what are known as internal care plans in respect of their worldwide operations, so including suppliers and subcontractors. And the aim here is to seek out and mitigate breaches of corporate and social responsibility rules. So companies are increasingly being targeted, and in significant part, this trend was accelerated, I would suggest, by the Shell decision of last year. Finally, financial institutions. This has been a more recent development, but cases have started and are likely to continue to emerge, particularly as the recognition of the role that financial institutions have in promoting the broad ESG agenda, and in particular directing capital flows, of course, continues to grow. And this is bringing a heightened level of scrutiny, as we all know, of behaviour and conduct in the financial services sector, business and investment activities, and including, of course, financing of other sectors. So we're seeing a number of contributory factors in play here. First, the growing number of potential claimants. Secondly, the developing case theories that are being relied upon. Recall here that there is no, as things stand, at least in this jurisdiction, or in fact in any jurisdiction that I'm aware of, there is no general ESG cause of action thus far, but there are developing case theories. Thirdly, the fact that litigation is being deployed in the ESG context as a tool to encourage or compel behavioural change, which is really a new departure in the context of litigation. The final point I'll note here it is also a crucial one, and this is a crude generalisation, but overall what we're starting to see, at least in some jurisdictions, is more of a judicial willingness to entertain the types of claims that are being brought and progressed in this context. That was historically the case. Again, often based on new or developing case theories, and perhaps, for example, targeting parent companies as opposed to operational subsidiaries. And this is something we're seeing in the English courts at the moment. And again, this is changing the landscape. So I want to close by spending a few moments talking about specific risks in Europe and the UK for financial market participants. And I've touched on some of these in my remarks already. As I mentioned, while they are less prevalent than in other contexts, actual filed claims targeting financial institutions do exist and are emerging, not least as the regulatory noise and attention on financial institutions continues to increase. So where are the key exposures likely to be against that backdrop? Well, as disclosure requirements, including in relation to both quantitative and qualitative information, continually increase, this has been a theme of this talk or this session already, as they continue to increase, performance against targets and commitments will be scrutinised more closely and shortcomings will be picked up. This is really a key emerging area of risk. And of course, it brings with it not only direct liability exposures, if, for example, misstatements are found to have been made, but also very significant reputational risks. In the context of publicly traded entities, of course, that in itself carries its own risk if bad news stories or revelations lead to precipitous stock drops. That's probably less of an issue. Well, it certainly is less of an issue as things stand in Europe and the UK than it is in, say, the US, but it's certainly not unheard of, and the dynamic is changing. Now, a related area is in the context of due diligence, where a number of cases have started to emerge. And these tend to have to do with finance, specifically with financing and investment decisions that are made. They usually involve more conventional plaintiffs or claimants, ordinarily the organization's clients or investors. But again, there's a changing backdrop to all this. Now, even if, let's say, in the debt capital markets context, prospectus information is focused solely or principally on creditworthiness, increasingly it will be the case, increasingly it is the case, that some ESG due diligence and disclosure is going to impact the issuer's creditworthiness. ICMA has recognised this, for example, in the context of use of proceeds information for a green, social and sustainable bond issuance, or information that's central or integral to the issuer's principal activities. So if there are shortcomings in the diligence in these areas, it's easy to see how liability might attach, and that may be premised on either a primary or a secondary liability theory. But ultimately, what we're talking about here is a failure to identify or properly to price climate or other ESG-related risks and exposures. Now, when it comes to the principal activities of financial institutions, a number of specific areas are emerging as focal points for of scrutiny by investors and clients in particular, and especially as ESG considerations become more prevalent concerns in choosing products, assets, projects to invest in, and so forth. So how has how has the ESG performance of a particular investment or product, how has that been assessed? What metrics have been used to assess specific climate risk as well as specific financial risks? Are the conclusions that have been reached properly supportable by the data, by the diligence? Closely linked to that issue is the question of asset valuations, particularly those which might be described as ESG exposed, and those that are potentially vulnerable to valuation changes as we transition to a low carbon economy, for example. And at the extreme, of course, assets which have the potential to become stranded. Now, closely linked and indeed overlapping with that issue are issues of greenwashing. And this is really where the flood of new legislation and regulation is having a highly significant impact. And it's also where a lot of stakeholder scrutiny is focused. And what we're talking about here is the accuracy and the adequacy of the disclosures that are being made in key documents, whether they're bond prospectuses, marketing materials, annual reports, financial statements and the like, or just in the advertising context. The emerging regulatory framework and the liability regime, together with changes in investor expectations and requirements, are likely to be highly impactful in this context. Now, greenwashing really is the focus of much of the emergent liability exposure and much of the public anger and outcry. ESMA recently identified greenwashing as a key focus in its sustainable finance roadmap, and the SEC has done similarly. And other regulatory bodies are also taking a close interest. Very recently, just last week, I believe, a major international financial institution was targeted here in the UK by the Advertising Standards Agency on the basis that it allegedly misled customers through specific advertising in relation to its green initiatives and its role in the climate change crisis. Whether or not this will lead to civil litigation involving the institution remains to be seen, but the development really clearly reflects a markedly increased level of scrutiny of what is being said and done in relation to ESG. So I'll close with this. What we're seeing developing are, in some cases, novel liability theories in the context of litigation, targeting not only national governments and private entities, but increasingly to some extent, and it is still a limited extent in this jurisdiction, financial institutions also. These include primary and secondary liability theories and reflect an increasing willingness to use strategic litigation as a tool to encourage behavioural change. And crucially, as I mentioned, some judicial willingness to entertain, hear and rule on claims of this nature. So I'll leave it there on the European position. So with that said, let me pass it over to Mark to talk a little more about the US position. Thank you.
Thanks, James. Hi, everybody. It's nice to see the numbers on the computer. Much of what Paul and James have said, I will echo. I want to focus on the US, of course. I'm based in the US. I monitor this area on a daily basis. I find it fascinating. And many of the themes that James in particular outlined are echoed in the US. There are some profound differences, though, that I want to focus on. So from the US perspective, the E piece of ESG is the most well-developed and instructive for our purposes. And to cut to the chase, financial institutions really are not in the crosshairs so far in the environmental climate change litigation risk space. The litigation lawsuits in the US have been brought primarily by, as I've said here, NGOs, municipalities, counties, and to a lesser extent by individuals and shareholders. And the targets of these cases are typically governments and governmental agencies. Those claims are claims brought to get governments to do what they're supposed to do, or what a particular NGO wants them to do, or what the governmental agency's mandate is, etc. There's another category of cases, though, that have been brought primarily, not exclusively, but primarily against fossil fuel companies. And those cases are framed normally as nuisance cases or fraud cases, sometimes deceptive practices under state law, etc. But financial institutions, we have not seen direct liability cases yet. Slide, please. There are a bunch of reasons for that, and this goes to precisely what James was talking about. The motivations in climate change litigation is a little bit different. The classic motivation, of course, is money damages. Plaintiffs want money damages. They want to recover money. Plaintiffs' lawyers, often operating on a contingency basis, want to get a piece of that. And so that's what motivates litigation. But in the climate change space, money damages can be a part of it, but oftentimes the cases really are to affect conduct, to force a government to do this or that, to force a coal extraction company to stop extracting coal, maybe to shame market sector participants from a certain course of conduct, whatever. Also, there's a whole public awareness component to climate change litigation, and that is filing a complaint, holding a press conference, and making a splash. And honestly, those cases are probably the majority of cases that are being filed nowadays in the United States. Slide, please. So what's the scorecard been on climate change litigation? Well, frankly, most cases have not gained much traction. Many cases have been dismissed on standing issues. Remember, the issue of Article 3 standing is, does the plaintiff suffer an injury in fact? And oftentimes, an NGO, for instance, can't really point to an injury in fact that it has suffered. Increasingly, there are issues concerning political questions, and I'll come back to this. But courts in the United States really refuse to rule on cases that are better addressed as a constitutional matter by the political branch, which of course is somewhat perverse, because what's motivating many of these cases to be brought in the first place is the inaction by the political branches in the United States. But that is the state of the law, and that's one of the reasons why many of these cases are dismissed. And even if the cases are not dismissed, there's a lot of jockeying that goes on concerning jurisdiction and what's the proper court and what's the proper venue. And there are a host of cases involving the state of Minnesota, municipality of Honolulu, Baltimore. These are pretty high-profile cases that have just been involved in this morass of trying to get going on their case. And the defendants have been very effectively preventing the cases from moving forward, pointing to jurisdictional problems. And those cases really haven't gotten off anywhere. And then even once these cases go forward, and James alluded to this, science is improving. Science is allowing some degree of causation and attribution to be targeted to certain defendants. But the truth is, if you think about the Honolulu case, Honolulu is suing ExxonMobil and others for the rise of sea level and beach erosion. So essentially what Honolulu has to prove is, did company X emit CO2, which caused glaciers to melt, which caused the water line to rise, which caused Honolulu to have to spend money to address flooding issues and beach erosion? Well, that's a huge chain of causation that's going to be very difficult to establish as a matter of US law. And taking it a further step, suppose they could establish all of that. Well, then the question is, well, how can this really be laid at the foot of company X? What about companies Y and Z and all the others that also contributed? And frankly, litigation is something of a blunt instrument or blunt tool to address these kinds of questions. So there's something to be said for this political question notion that these are problems that have to be solved on a much more holistic basis. And litigation, particularly civil litigation in the United States, is not well suited to establish it. And finally, discovery, which is a huge motivator for plaintiffs in the United States, has been stalled for the reasons that I've just gone through. And the bonanza that can occur, which leads to the disclosure of embarrassing memos or emails or research that's been deep-sixed for 20 years, that hasn't happened yet. Slide, please. So what are the implications? Well, the implications are the litigation market has built-in efficiencies, and the plaintiffs' bar and litigation funders are really not interested in these lawsuits. It's not to say they don't have merit. It's that these are difficult cases, and these are well-funded defendants in the crosshairs. And for fossil fuel companies, frankly, these cases are existential. So the secondary liability cases, which are cases that would involve financial institutions and accounting firms, haven't taken off because the primary cases against fossil fuel extraction companies, for instance, have really not gone anywhere. And so the monetary rewards associated with these cases simply don't exist at this time. And that's one of the main reasons why we're not seeing financial institutions targeted here. Now, the US regulatory framework remains very much in flux. That will change, and we've talked a lot about disclosures. And once disclosures become more crystallized and measurable, that could change this landscape somewhat. Slide, please. But of course, climate change litigation is not just about dollars and cents. It's not just about winning in a traditional sense. So the financial motivation is not always what's driving these cases. We have shareholders and activists. Paul talked at length about that, how that is certainly on the rise, and NGOs. And increasingly, we're seeing NGOs coordinating with one another. And they're very open about their objectives. They're not necessarily trying to win the case in the traditional sense. They issue press releases and they seek to make a splash, as I said before. That's strategic litigation, and the objectives are not primarily financial. And studies show that there's an increasing and growing concerns about climate change in, the regular population, particularly younger people. And for these reasons, these NGOs are trying to use litigation as a tool to affect corporate conduct, raise public awareness. They don't really care about winning or losing in the classic sense, as I said a moment ago. So we see cases filed against, and I'll get to these a little later, the likes of Coca-Cola and Exxon and Starkist Tuna, trying to raise different issues to the forefront of public consciousness. And that can be a win. Slide, please. So one of the questions I asked myself is, well, are we going to see the Royal Dutch Shell case, the one that James spoke about a moment ago, arise in the United States? I've been asked that by a number of clients. What about the United States? Can this case go forward? And I think the answer is no. We haven't seen a case like this. The closest thing we've seen, in my judgment, and others may disagree, but is the Juliana case, which is a very highly publicized case that I've talked about before. That's a case brought by 20-odd young people that sued the US government, alleging that its failure to act violated their rights under the US Constitution. And the Ninth Circuit, which is probably the most liberal court in the United States, poured this case out on standing grounds. They said that this is not the type of case that can be redressable. And of course, they focused on this political question issue I alluded to a moment ago. And that's really in the forefront. On this day where the Supreme Court is in the news, I'm reminded, I read this article a few weeks ago about how when Judge nominee Ketanji Brown Jackson was being asked questions, Senator Grassley asked her about questions, what are you going to do with cases that implicate political issues? And this is precisely the political question that is at the heart of the US analysis of many climate change cases. And what she said was, quote, if a person comes to the court and they ask the court to answer something that is properly in the province of Congress, comma, if they ask a political question, then the court has to say, I'm sorry, that's not my role, close quote. And that's the huge difference between the US litigation system and what we see in Europe. James alluded to copycat cases. The prevailing plaintiffs in the Royal Dutch Shell case have already lined up a number of different lawsuits in different jurisdictions against different corporate defendants. So it's just very unlikely we're going to see a case like that in the United States because it's essentially hopeless. So you might say, well, wait a second, you just spent the last 5 minutes talking about how NGO motivations really don't care about success. Success is measured by different metrics, and I guess that's true. But the truth is, the cases that we see in the climate change space have just been bogged down in procedural and preliminary motion practice. They haven't really gone anywhere. Unlike the Royal Dutch Shell case, which has come to a crescendo, and of course it's on appeal, but success breeds success. And we're seeing more cases like this in Europe, and we're not seeing cases like this in the US. I don't think that's going to change. Slide, please. So what does that mean? Does that mean that banks don't need to worry about climate change litigation? I don't think so. I think that the risks are a little bit different. The risks have to do with reputation. That's pretty clear. For instance, when banks are associated with funding gas pipelines, the Standing Rock controversy comes to mind, which many of the people who are attending this know about. financing coal extraction activities, et cetera, reputational risk is important, and NGOs are all too willing to shine the spotlight on financial institutions that are engaged in behavior. So that can be deemed anti-green or non-climate friendly. So banks certainly need to be aware of those types of risks. There are counterparty risks as well, credit risks. I cut my teeth on cases as a young lawyer on asbestos cases where companies were driven into bankruptcy because of asbestos materials placed inside buildings. So, a bank needs to be well aware of who they're doing business with, and are they going to be the target of one of these lawsuits that drives them into bankruptcy? So these are sort of like rebound risks, et cetera. Transition risks of stranded assets is something that gets a lot of attention in the press, where financial institutions are financing, let's say, coal-fired power plant. Well, if that's taken offline, if that becomes efficient, if that becomes driven out of business, maybe by consumer preferences or technological developments, that's going to negatively impact the collateral that particular financial institution is holding. So one of the things that James alluded to, which I find fascinating, and this is something that we've given a lot of thought to in the United States, is the failure to adjust to these types of risks. These indirect risks that I've outlined can lead to exposure, particularly directors. Is upper management adequately taking account of climate change risks? Are they acting in the shareholders' best interests? These could result in claims for breach of fiduciary duty, if there's a loss in share value, derivative claims, et cetera. So that's one category that I think we have to watch, the risk of inaction. And of course, there's the risk of overreaction, but that's for another conference. Slide, please. And now disclosures, which is really here and I think coming as mandatory disclosures start to take off. The risk here is inadequate or misleading disclosures, and it's not just disclosures that are made in public filings or annual reports or contracts. It's also statements that are made in social media or on websites or in advertising. Those are the types of disclosures that have led to lawsuits in the United States. Now, most of those claims, I have to say, have foundered. They have not been successful. And that's because there are serious reliance issues. General claims like "we care about equality," for instance. It's very difficult to call that a material or a false statement that could lead a reasonable investor to invest in that particular entity. Puffery is a great defense that's available to corporate defendants that just say, look, these are just aspirational statements. These can't be measured objectively. We can't be sued for those things. And for the most part, courts have agreed. That will change as mandatory disclosures start to pin down institutions, financial and otherwise, to make disclosures that can be measured, that can be checked. That's going to change. Now, of course, objective measurement in this space, as Paul was saying, is very hard to get your arms around. I mean, what does carbon neutral mean? What does it mean 10 years from now, or aspirational statements about what you're going to be doing in 50 years? And what about safe harbors? So even though mandatory disclosures are coming, that doesn't mean that there's going to be a slew of successful litigation for failure to live up to those disclosures, because I think they're going to remain very difficult to quantify and pin down. And finally, greenwashing. I do need to spend a couple of seconds on that, only because that, as we all know, is the process of conveying a false impression or providing misleading information about how a company's products are environmentally friendly. And it's often an effort to capitalize on a growing demand for environmentally sound products. And in the past few years, there have been, I have to say, countless lawsuits filed in the United States and around the world regarding greenwashing, whether it's Coca-Cola or Poland Spring about statements they make about plastics, whether it's BP or Exxon talking about carbon emissions, Tyson Foods for the ethical treatment of animals, Starkist Tuna for dolphin-safe and sustainable tuna, Keurig for recyclable plastic pods, and on and on and on. There are tons of these cases being filed. And these cases are driven, as I said before, primarily by NGOs that are shining a spotlight. Most of these cases fail at at the outset. But as greenwashing becomes more and more a focus of legislators, I think that these cases are going to start to stick, and most companies, frankly, back down, right? They're accused of greenwashing, and then they stop advertising in that particular way, or they adjust their website, and so on. There is an interesting case that's proceeding that's sort of adjacent to greenwashing that I just wanted to bring to people's attention because I find it interesting. It's a case in Massachusetts. Massachusetts has sued Exxon, and Massachusetts has accused Exxon of a number of things, including a greenwashing misinformation campaign, misleading customers and investors about their products. Exxon has responded by saying, well, its lobbying and advertising is actually free speech, and it's protected under Massachusetts anti-SLAPP laws. Now, this is a fascinating case. It was just argued in March, and it remains to be seen what will happen. But it's one of the few cases that I'm aware of where a corporate has really walked right into the teeth of a greenwashing claim and said, yeah, we're actually allowed to do this, and this is why. So in any event, the bottom line needs to be for anyone listening to this is actions have to match your words. If you promise something to your customers, you've got to deliver that. If you know something, you need to disclose it. Materiality and honesty are the best policy here. So let me stop there. Paul, turn it over to you for some wrap-up remarks.
Thank you, Mark. And just to close, much of this is self-evident, but it's probably worth repeating. As both James and Mark have highlighted, disclosures, public statements are becoming more and more important and obviously more detailed as a result of granular mandatory reporting. Accuracy becomes essential. There are obviously the risks that what you say is not what you do. They're becoming more easily identified, especially as the data gets more granular. I would note, just as a sidebar, that we've seen evidence of plaintiffs using natural language processing. So just narrative disclosure is not safe anymore. People are really scrubbing the narrative disclosure in addition to the actual data and metrics. All entities would benefit from very focused groups within their institutions to really seek to address ESG risk and the issues and disclosures that we've been talking about. Very few institutions are set up that way, and we find many clients struggling with the need to sort of reconstitute their governance arrangements to make sure they have, in fact, effective control. And just to take a point, Mark said, are you scrubbing your social media disclosures in the same way you do your public filings? If the answer is no, and you're talking about ESG disclosures in your social media, you need to fix that. And you certainly need that group to be up to speed and working towards compliance with a very rapidly evolving area. We didn't mention, but we should, the SEC is now overdue for what they refer to as the names rule, which will be the US equivalent of the MiFID and other requirements that exist in Europe as to how funds are able to describe their products. That's going to be another significant development here in the near term. And certainly, again, as you dig into value and supply chains, and you discover, particularly if you're reporting Scope 3 emissions, the inadequacy of data, it's just a massive data chase that will go on. And clearly, you need to be focused on it. You need to devote resources to it. You need to make sure that the resources are properly trained and qualified for that to be successful. Next slide, please. And I think the closing takeaway is, hopefully, as we've identified, you really do need to think about ESG litigation in a different way. You have to understand its nature and how it's different from conventional litigation. We've talked about the differing nature of plaintiffs and claimants, and certainly the nature of the relief that they seek. There's certainly a theory that there is a benefit to an early engagement and collaboration with stakeholders. I mentioned in the context of shareholder activism, we are seeing companies more willing to reach settlements and to voluntarily agree to increase disclosure or changes to governance or something in order to avoid expensive litigation. And certainly all out-of-court solutions should be on the table. Again, the reputational risk is a pretty low bar for many. And again, it's something that will take a lot of work to ensure that you are on the safe side of. Next slide, please. I think that may be the last. And just mini advertisement from Mayor Brown. Our ESG group is now several years old. It now comprises over 135 lawyers, broadly diversified by their geographic location as well as their traditional practice. We joke that it's all ESG all the time at Mayor Brown, and sometimes it's not really a joke. The materials include links to our webpage. We obviously publish frequently, including our most recent one yesterday on the SEC's ESG task force bringing their first case against the Brazilian mining company, based in part on their disclosures that were made in their corporate sustainability reports, not their public filings. They were bad too, but certainly the complaint alleges that there were misstatements in their corporate sustainability reports as well. And last but not by no means least, just because it's probably our most active voice, is our Eye on ESG blog. So with that, we're going to conclude our presentation today. I see we're just a couple of minutes over. We certainly thank you for your time and attention. We hope you found this worthwhile. We encourage you, as usual, if you have any questions, to reach out to any of us at any time. And with that, we're going to close, and you may all now get back to the rest of your day. Thank you again.